Hi guys, it's Kathy. I hope you're doing well. YouTube decided it didn't want to do anything this morning, but I bullied it into getting to work. We have work to do. So next week is pretty much the same as this week, but ugh, we did a premiere one day, and then I canceled the stream yesterday, so that wasn't too bad. It was only 2 days, and we're back, so we'll be all right. We won't have any streams Wednesday night because I work a double. Now that was the last stream that you're looking at. So let me put this stream. Oh no. That's today. Okay, what I got for you today is all Colorado craziness. Ugh. This one guy's pretty violent. I don't know if Bobby's here. I didn't see Bobby, but Bobby will be happy with today. We get some handcuffs a couple times today. That's okay. Let's get started, and then I'll fix the chat feed. Here we go.
Mr. Salazar, the next date that you need to appear for is going to be on October 19th at 10:30 a.m. You need to be here in person that day, sir.
I agree to try to arrange transportation, but I think you should be well aware that Terry Reeves, the Crowley County Sheriff, advised me that I was indefinitely unpermittable into the Crowley County Courthouse.
Well, you've got over 2 months to find a ride, Mr. Salazar.
Terry Reeves told me by threat of jailment that I was not permitted in the Crowley County Courthouse.
Well, we can take that up on October 19th at 10:30.
But I fear my freedom might be jeopardized, as Terry Reeves told me he would arrest me if I came to the courthouse and entered.
Well, you can choose to come here on October 19th at 10:30 or not.
But Terry Reeves told me I couldn't.
You can talk about this with your attorney, Mr. Salazar.
And Your Honor, can I just confirm there's no court order prohibiting him from coming to the courthouse, to my knowledge?
None that I know of, sir. So
But then why did Terry advise me there was?
you'll have to ask him that.
Well, why wouldn't the courts be asking him that? The courts are the ones that allowed him to tell me that.
I didn't know about it until just now, sir.
When I spoke to you on the last court date when he gave me the paperwork, you were well aware of it, sir.
Okay, Mr. Salazar, we'll see you on October 19th at 10:30. This matter's now in recess.
But you ain't even answering. You were already well aware of it.
Good day to you, Mr. Salazar. Court will call 265, People versus Hunter Rook. Mr. Rook appears in person. He's pro se.
You guys ain't being very fair in your ruling.
Thank you.
Ms. Hardy appears on behalf of the people. We're set for status conference today. Can we mute Mr. Salazar, please? Or can we eject him?
Why am I not being...
Lauren Agee for the people.
Grant Grosskabauer on behalf of Mr. Hanbury, who is approaching the lectern.
They kicked him out, so we didn't hear any more from him after that.
Alrighty, the matter today is set for sentencing. The court now has the PSI it did before, as well as the record of actions filed by ComCorp, along with a number of supplemental exhibits and documents that the parties wish for the court to see. I have all those things. Do the people have them all?
Yes, thank you.
Does the defense have them all?
Yes, Judge.
Any additions, changes, corrections to the PSI, Mr. Grosskabauer?
Judge, I do, and I'll address mostly a lot of these in my comments about sentencing.
I just feel that judges do not use contempt of court enough in the court. I just feel if I was in a courtroom and I acted like that, I'm 1,000% sure I would get contempt of court.
Sentencing range, I believe, should be 2.5 to 4 an attempt of a COVF4 should be 2.5 to 8, but given the cap in the case, it should be 2.5 to 4 in this case, should the court impose a DOC sentence. And I'll talk about this a little bit more as well. In the defendant's statements or comments section, it really just says he completed an attached questionnaire. I don't often attend PSIs. I do for younger clients. And in this case, I attended Mr. Hanbury's PSI, and he talked extensively about his role in this and how he felt and his apologies towards the victim. So I'm a little frustrated that those were not included in the PSI. I think that those are...
Yeah, okay, he's real sorry for what he did to the victim. Bullshit. That's bullshit. I've never heard bullshit like that before in my entire life. I think they show a video here, but I don't think we get to see it. However, I kind of feel it's good that we don't get to see the video. I don't know if I really want to, because this guy right here, he's on the left. He's standing at the podium. He's the shorter one standing at the podium. His lawyer is the taller one. This guy right here is dangerous, the guy. But we'll hear more.
Important. I don't understand why that's missing here, at least some mention of it. It's something he's going to address further in his statement. And then finally, it talks about the response to supervision. I don't know if this is an addition or correction, but it basically says the defendant, his current compliance with the conditions of supervision were unknown. I was able to look him up in 5 minutes, and I can tell the court about how he's doing on probation, and I will do so in my sentencing argument. But that's more of an addition, I think, is how he's been doing on probation in the last year or so since his case was filed.
All right, thank you for that. Any additions, changes, corrections for the people to the PSI?
No.
All right, are the people prepared to proceed?
Yes.
Is the defense prepared to
Yes,
proceed?
Judge.
All right, I'll hear first from the people as well as the victim, if the victim wishes to be heard, and then from the defense. The defendant will have the final word if he wishes to make a statement.
I'm not sure, Kit Kat. It wasn't my fault this time.
But that'll be up to him.
Judge, is there a way the people can reserve a quick rebuttal for after the defense's statement?
I'm not a huge fan of that. I don't want to make it a habit. Let's see how things go. If you feel there are issues that you really need to address, I may allow it, so don't count on it. I may.
Thank you. I do have two victims here who'd like to speak. They're both VRA victims in this case.
They may.
First is Justin, I'm going to say your name wrong, Piltinsrud.
Just come right up here, sir, to that microphone. And then tell me your name before you tell me whatever you want me to know.
My name is Justin Piltinsrud.
I'm sorry, last name, sir?
Piltinsrud.
Okay, thank you very much. Go ahead, sir.
Your Honor, my wife and I were attacked without any confrontation or provocation. My wife is still recovering and attending physical therapy, and I now have a steel plate in my face, and half my cheek is still numb and my teeth are still numb on my left side. This has a significant impacted both of our lives. And the most difficult thing for me is knowing that we were attacked with no reason, is worrying about what this means for the safety of our children. I would like to ask the court to impose the maximum sentence allowed, not only because of what happened to us, but to hope that this would prevent this from happening to someone else. Thank you.
Thank you, sir.
Next, we have Lacey Wolf.
Okay. And ma'am, I know she just said it, but if you just tell me your name again.
Lacey Piltinsrud.
Thank you very much. Go ahead, ma'am.
Have you seen the video?
I have not seen the video.
Okay. After seeing what happened that night, I watched this man violently assault an elderly man. And when that man is already incapacitated and unable to defend himself, the defendant vigorously kicks him. That alone tells me enough about this man's nature. You see on the video, what you see is only the beginning. Video can show you punches, the bodies hitting the ground. I can't show you the 9 months of hell that my family has gone through since. My husband is strong, but gentle, and he is the kindest man that I know. That night, without a single word exchanged, without an argument, without any provocation, this man struck him without warning. My husband had no choice, no chance to defend himself because he had no reason to believe that he needed to. And somehow, my husband carries shame for that. He questions why he didn't protect himself or his wife, as though he could have magically foreseen this violent stranger going to attack him. I have no memory of the violence that night. I remember being excited. Our friends had taken us out to celebrate our birthdays. I remember playing the piano with my girlfriend and then heading to go get my husband's favorite tacos. It started out as a really great night until we unceremoniously met this man. For me, my consciousness was blank until my brain seemingly came back online in the ER. I was told that for several hours after, I repeatedly asked the same questions because I was unaware of what had happened. I didn't know why I was bleeding. I didn't know where my husband was. When I watch the video, I see a man who had already hurt 2 people. I see myself try my best because someone needed to try and stop him. And then I see where I become the 3rd person to experience his violence. For the defendant, Your Honor, it was one night. For my family, it's been nearly 9 months of hell. Our children have had to worry about us and care for us. My oldest, which is the same age as this man, has had to become my memory. I couldn't work. I couldn't cook or drive or function normally. My injuries took away my ability to support my family the way that I was able to before. We were forced to take out a loan, which we will be paying off for years just to try and survive. I have lost countless short and long-term memories. The most painful being my children's childhood. Memories that belong to my family are gone because when they're little, they don't know what happens, and that's where their parents come in, and I can't share those memories with them anymore. I used to be a high-functioning woman, Your Honor. I was eloquent. I kept our family moving. Professionally, communication was one of my greatest strengths. Now I write everything down, put everything in calendars, I set alarms, and still, I make constant mistakes. Several times a day, I lose words or concepts in the middle of conversations. And not normal forgetfulness. It's like the word is simply on the other side of a veil and I can't touch it. I can't reach it.
I often forget things. And then I also often forget things.
I know it's there. I just don't have access. Nine months later, I still suffer headaches. I still experience dizziness. I have a very permanent, very ugly scar and bald spot on my head. Laying down to sleep or rest hurts every night. Where I once had confidence feels like I have a ceaseless anxiety. But what hurts most
Oh, Jude, that sucks.
is knowing that my children can see that their mom is different now.
It's all right. Take your time, man. Take your time. It's all right.
I'm not as capable as I was. I'm not the professional that I was. I'm not the same wife, and I'm not the same mom that my kids had. Because of this man's choices, parts of who I was are gone. Because of his behavior, I am less. Your Honor, I'm told that we weren't his first victims. The defendant was already on probation when he attacked us. The justice system had already intervened. There were multiple victims, restraining orders, consequences, and multiple chances given to this man before that night. Those chances didn't protect that elderly man. They did not protect my husband, and they did not protect me. We survived that night, but I ask if he's given yet another chance, will his next victims be that fortunate? Our family has spent 9 months living with the consequences of his choices, and some of those consequences may last the rest of our lives. Please do not ask another innocent family to pay the price for one more chance. I'm asking you to impose the maximum sentence permitted under the plea because the plea itself has already given the defendant a significant measure of leniency. Anything less than the maximum allowed will fall painfully short of justice for the people who've already paid the price for his actions. Please give us a reason to believe that our justice system sees the people whose lives are permanently altered by his violence, and that protecting innocent people does matter.
Thank you. Thank you.
Judge, I do have a video I'd like the court to see as part of this sentencing. While I'm pulling that up, I will just give some context of the video. This is an incident which occurred at a bar in Littleton. The defendant committed an assault on, I believe it was the patio of the bar.
Now, this is this event, right? You're not
It was
trying.
the same night.
You want to play me a video of another event?
No,
This event.
correct.
That's all I need to know. Okay.
Just the context of this video that I'm going to show to the court, which is this event with these victims. There was another assault incident by this defendant earlier in the night. That's not charged based on the investigation we had at the time. With the plea going through, the people did not investigate further at that time. I will just note that because this assault incident with these victims was not the first assault that night committed by the defendant. But I will show the video of these two victims who spoke to the court very quick. So
Let's just,
please,
has the defense seen this before? Okay.
yes. Please let me know if the court wants me to replay it.
All right.
And just to orient the court to look in the, I guess the top right corner is where the victim, Justin, is standing. And I do have the video on a disc if the court would like
I don't.
to review it further. The black hooded individual is the defendant here. A couple things that people would like to point out for the court. This is quite possibly the most unprovoked assault that I've seen in this job. Both victims here were just minding their own business, waiting for some food at a food truck when the defendant, already being belligerent, came up and punched Justin unprovoked. When Lacey tried to get involved, he turned around and pushed her down, pushed her, and she had hit her head, leading to the injuries she told the court about. This is not a self-defense case. This is not a case where there's any sort of provocation by the victims. This was completely random, wrong place, wrong time, act of violence by the defendant. The defendant has had many opportunities at probation. I'll just point out the criminal history in the PSI. Starting as a juvenile, assault. 2024, assault. A VPO out of Douglas County. September of 2024, a different assault. Another VPO. And then this case. The defendant is really young, Your Honor. So the fact that he has already 3 separate assault matters on his criminal history prior to this one is extremely concerning to the people. The people don't believe giving him another chance at probation is appropriate given this history and the aggravation of this case. I know that the defense is going to talk about all of the things the defendant has done since this offense to straighten out his life. But I asked the court to consider, how come that didn't happen in 2019? How come that didn't happen in his second assault case in Denver in June of 2024? How come it didn't happen in September of 2024? Here we are about 9 months after this incident. The people don't believe giving him another chance when he's already had these other chances for the same type of violent history would be appropriate here. I would note that the conduct in this case involving the defendant's behavior of punching people, I will just note that my office has seen murder cases that result from the same type of behavior. People believe that this type of outcome here affects the victims forever, as the court just heard from the victims. This isn't an injury that could heal ever. Beyond the physical injuries, there's the emotional injuries, financial injuries, as well as the lack of memory that Ms. Wolf has now. Those types of things impact members of our community forever. And I would just note for the court that I know the court sees a lot of similar charges come through this courtroom. And in a lot of those cases, the victims may or may not have done something wrong in order to impact the case. These are
And there you go, guys. She just gave you the answer of what's about to happen. So, she said, I know you guys see a lot of these similar charges come through this courtroom. So what's probably going to happen is he's going to get a similar sentence to what we similarly see every day.
Completely innocent victims here. They're just minding their own business and had no interaction with the defendant prior to this. So I would ask that the court consider a sentence to the Department of Corrections. I would note that one of the purposes of sentencing is punishment. I do think that maybe on one's first offense, the court should explore more rehabilitative options. But on a fourth assault case at such a young age, people do believe that some sort of punishment should be.
Okay, all right. I know she just said fourth assault case. But I don't know. All right, and this right here, he assaulted 3 different people that I know of: an elderly man, the husband, and the wife. And he was on probation. So that might be the 4 cases right there. He might not have already had 3 prior, although he could. I don't know. It doesn't say exactly. So I don't know if he had 3 prior and then this whole escapade was the 4th. He had 1 prior and this whole escapade equals 4 now. I don't know.
Required. Thank you.
All right, thank you. Mr. Grosskopf.
Judge, we don't have any witnesses, so I'll just sort of jump into it. The court's seen all my filings in this case, and now the court's seen the video. And look, we don't justify that video in any way. This was never a self-defense case. This was a case my client, since the moment he saw that video, has wanted to take responsibility. And for what it's worth, he has no memory of that night. And that person who's in that video, he has no memory of being that person. And I think that's why this is particularly hard. Judge, before you is a 22-year-old young man who's facing a sentencing on his first felony conviction ever. He's someone who, as the PSI notes, has struggled with substances since he was 13 years old. Someone who struggled with severe mental health disorders like bipolar since he was 15. I filed all those records with the court. It's not often that we have actual records that back it up. This is not something he made up after the fact. This is something that he's gone back and forth with and struggled with for a long time. And I wish, like Ms. Agee says, it just took one case and he could straighten himself out. But sobriety is not a straight line. Mental health issues are not a straight line. And when you combine them together, those combinations can be catastrophic, not only for people who suffer from them, but unfortunately for others around. That doesn't always have to be the case, though. And I think with treatment, with stability, and with structure, that's the only way through for Mr. Hanbury, and the only way I think that true justice is considered here. Your Honor, the court has to consider that since this case was filed, the defendant has been perfect on probation. I pulled his probation records. I'm happy to share those with the court. I was hopeful that the PSI would have tried a little harder to do so. He's been perfect on probation. He's attended all of his classes. He has not missed a single UA. He's been sober since this case started. And he sought out additional treatment outside of what was ordered by probation. He completed an intensive IOP program. I filed that with the court through All Health, where he met 3 hours a day, 3 times a week for 12 straight weeks. And then he engaged in more treatment after that. This is in addition to the classes probation was asking him to do, in addition to maintaining.
These are all the words judges need to hear, guys. He's saying everything the judge wants him to say.
His job, in addition to taking all the UAs. And I think, and something I'll talk about here in a moment, he moved back in with his parents, and they're sitting here today in the courtroom. He comes from a good home. I've met his parents. I met his mom on dozens of occasions, and I know how much she loves him and supports him in this. She wrote her letter to Your Honor as well. I think moving back in with his parents has been hugely stabilizing for him. He's also taken steps to improve himself outside of just taking classes. He enrolled in his GED classes, just recently passed his final exam and obtained his degree. He's since now enrolled in college classes that can help him with his job in the family business of accounting and bookkeeping. And I think he has a new lease on life, no matter what the court does today, because he has a 1-month-old that's sitting outside the courtroom with his girlfriend. And he's expressed to me just how much that has sort of changed the person and the trajectory that he has for himself in his life. Judge, we can't ignore the criminal history here. I'm not asking the court to. But the court should put this into context. Within a short period of time, the defendant picked up a number of assault cases. But what actually caused those, aside from this confluence of mental health disease and substance use? Mr. Hanbury during this time did what many young people do, which is he went out on his own and he rented a home with his friends.
You know, if he was on drugs, I think they were saying he was drunk or on drugs. So is it the drunk on drugs? Is it the mental health? Who knows? But they can lock him up in the hospital then. If he can't handle drugs, if he can't handle alcohol, and if he has mental health problems that he goes and just hurts random people, then he needs to be locked up. Period. But he has a baby. And he's going to classes. Come on.
and he moved in and he thought that he could handle the stressors of life as a 20-year-old, as a 19 turning 20-year-old. And he removed himself from the safety net of his family. And that's when these cases happened. All of them, back to back to back, happened when he was out living with this other group of friends. He's not blaming them, but he left the nest much too early. When he stepped out on his own is when these cases happened, and he realized he wasn't ready to live on his own. And since he's moved back under the supervision of his parents, and the cases have ceased, and he's become much more productive. And he's reestablished himself in the community, because that's all we can hope for. No matter what the court does today, this is a young man who, even if the court gives him a DOC sentence, is going to get out and be a young man again and be back in the community. But I think what's being asked for by probation, and to some extent Ms. Agee, is to repeat the same error, to take Mr. Hanbury, put him in a halfway house, put him in a community of bad influences with much older people with extensive criminal history who are paroling for violent crimes, who have addictions, and away from his family that's provided the needed stability. That is a guarantee that this sort of behavior, when he's removed from stability, has a chance of happening again. Now, he's a different man now, and he'll tell you he's never going to do this again. And those words only mean so much, because I'm sure many defendants standing in his position say the same thing. But his actions, I think, have shown, at least the last 9 months, what he is capable of. He's not going to repeat the same mistakes that have brought us here. That cannot be the way forward, is to put him in a home in community corrections as a deterrent, only to leave him worse off than when he came in. And he is deeply apologetic for what happened and the life-altering effects that this has had on these people. And I told the court this a moment ago, when he watched this video, I mean, he was so sincere and upset about what happened that, you know, he told me immediately how terrible this was. He's never doubted what he wanted to do in this case, which is to come forward and take accountability. But ultimately, he can't give them back what they had before. All he can do is be a contributing member of society again, stipulate restitution, get out of custody, pay these people back for some of the harm that he's caused them. And Judge, I don't think...
No, we want him in jail. That way he's sitting in his cell one day, and for absolutely no reason, other prisoners come in and beat him up. That's what we want. That's justice.
That the answer here is prison either. And I know how Ms. Agee feels about the case and the powerful words of the victims. That's one of the best victim impact statements I've ever heard. I've heard hundreds. And that was incredibly powerful. And we understand that. But we don't believe that sentencing a 22-year-old with a dual diagnosis to prison on their first felony conviction is cohesive with how others are sentenced on these types of cases. Judge, I think there are a lot of alternatives the court can employ here that are deterrent. Of course, his life is not going to be the same. He has a felony conviction for an attempt crime of violence. This is going to impact him forever as well. I don't think it is inconsistent with how the court sentences other folks to give Mr. Hanbury probation. Now, if that means probation with suspended DOC, probation with a lengthy county jail sentence, a lengthy period of supervision on probation, I think that serves the interests of deterrence, but also accounts for these mitigating factors and these things that, frankly, are out of his control. His mental health concerns are out of his control, but it's something that he's learning how to deal with and cope with. I don't think that's a far stretch for this court to do. And frankly, it puts more onus, and it gives maybe in some sense the victims what they want, which is he goes to probation. If he messes up, he's facing far more under this plea in terms of what he can get in prison. The cap goes away, and the court can sentence him up to 8 years if he were not successful on his probationary sentence. I think he's...
Sir, probation? Come on, you're not that stupid. You've been in court before, you're a lawyer.
Learned a great deal from this case, and he has a lot of work to do on himself. But ultimately, I think probation, or at the very maximum, I think community corrections ensures those factors, those sentencing factors are met in terms of rehabilitation and deterrence. I know my client also has a statement he'd like to make.
Hold on one sec.
Can I briefly respond to it?
I don't want to make this a habit. This will be the second case in a row. Don't plan on this. Go ahead.
Judge, I think that the argument that the mental health and substance abuse concerns cause him to act this way is part of the issues, because we see plenty of people in this court who have similar issues to this defendant who aren't committing violent crimes such as this. They may be committing drug crimes or property crimes. The violent nature of this case should be seen differently than the other defendants who have been sentenced similarly based on substance abuse and mental health issues. So that's all I want to say.
All right. Mr. Hanbury, I just want you to hear from me that you have a right to talk to me and you have a right not to. So you can certainly tell me anything you want to, but you don't have to. I want you to make your choice about it. And whatever one it is.
Nobody wants to hear from you, sir. Nobody. There's nothing you can say.
Fine. What do you want to do?
Heard a statement for the court today. Your
Okay, go right ahead.
Sorry. It's important to me that I express how truly sorry I am for the incident that happened at the bar that night. I was in a horrible headspace, but nothing excuses the choices I proceeded to make that night. I made a choice to go somewhere I legally wasn't allowed to go, to consume something that I'm not allowed to consume, with full knowledge that this type of thing happens to me when I drink. I have flashes of memory from that night, and all of them are horrible. I watched the video back one time before today, and I was sick, and I was shocked and disgusted with every second of what I watched. I take full responsibility and accountability for my actions that night, because had I followed the rules, used my resources, and worked it out the right way, everybody goes home safe. It's one thing to mess your own life up, but when your actions become destructive to other people, especially those you don't even know, I agree that serious intervention is required. And if the roles were reversed and something like this happened to me or one of my family members, I would want fairness and justice and consequences and whatever that looks like. Since the incident, my life has changed so drastically with the birth of my son and my girlfriend moving in with my family and the new connections I've made with people at church. I understand how important it is that we as a community hold each other accountable, watch out for each other, and secure each other by making sure that nobody's outside belligerent drunks starting fights and putting everybody's safety at risk. My behavior that night, leading up to that night, was absolutely unacceptable, insanely dangerous, and completely avoidable. Excuse me. The people I hurt were completely innocent and surprised by my behavior. Nobody should deal with stuff like that in life ever. I can't imagine the surprise and the fear and the adrenaline that it may have caused, as well as physical injury. I'm aware that incidents like this have a lasting effect mentally as well, and nobody ever deserves to go through something like that, especially by total surprise. And for this, I sincerely and humbly apologize. I know from this incident, I need to remain 100% sober from all drugs and alcohol for the rest of my life. I promise to the victims and to the county and to my family that I'll never show my face at another drinking establishment. It's not for me under any circumstances. I love the peace that my sobriety brings me, and I'm so scared to lose it. It and the emotional clarity that it brings. Nothing is more important to me than making sure I'm never involved in another altercation or another situation where I'm not in my right mind, because that puts everyone at risk. To the county, to the bar establishment and its employees, to my family, and most importantly, the victims and the families of the victims, I'm so sorry for the harm that I caused. I don't know all the ways that this has affected your lives, and I wish that I could take that night back every single day that I'm alive, because you did nothing wrong to me and you don't even know me. And I feel so horrible about this. I'm ashamed and remorseful, and I'll do whatever it takes to make 100% sure nothing ever like this ever happens again. You deserve justice and peace of mind, and I'm so sorry for the harm I caused.
Thank you. Oh. I think that I've been practicing law for 32 years. I represented a lot of people that did a lot of bad things. Thousands. I can't remember a case that I have dealt with, either as a lawyer or on the bench, that was just so randomly and utterly violent for no reason, with people that deserved none of it. And so I'm struck by this extreme violence upon people that just didn't deserve it. And then I review the history. And your history is violent, sir. You are a violent man. And you hurt other people for reasons that I don't understand. I see, according to the PSI, that at some point you decided to not take your meds. Maybe that's got something to do with it. But I worry about that. These folks, they didn't deserve this. They were just out having a good time. And you beat both of them. Oh my God. I have never understood violence like this with no reason. With no reason. These people didn't need to get hurt. And I don't understand it. It has never made sense to me, ever. What makes this case unusual for me is that, as Ms. Agee argued, I can usually see where this comes from. You can usually, at least there's some link to something, whether I agree with it or not, but there is none. The community is at risk from you, sir. You are a danger to the community. You are a dangerous man. And you're only 22. I was a little surprised to see the recommendation of the PSI here regarding community corrections because of your violent history, because of apparently the person you are for whatever reasons, and whether they can be fixed, I don't know. So I have to balance then this harm that these people didn't deserve and the things that they said about what they experienced and how that affects them now. It's all right. And they deserve none of it. Against what I see here. And the PSA's comments about the support you have, about the changes that you're making and willing to make, and the things you're willing to do to make sure that this doesn't happen again. Those words are a little hollow for the reasons that these folks pointed out to me, because you've been given a chance before, more than one. And so probation is not an appropriate outcome. It's just the same old, same old. We're just starting again with something new and it ain't going to work. They're right. It's not going to work. So the question is, what's more appropriate, a prison sentence or a community correction sentence? Prison mostly has one purpose. It's just to punish. And there's a rehabilitative aspect to prison, but it ain't really much. It's just about keeping people from harming others and making them pay with their freedom for what they've done. So the question is whether the defendant has put himself in a position where he deserves a prison sentence. And the victims aren't wrong that he does. When I balance their desire and the harm that the defendants caused upon the community, I think that the PSI brings to light some of the positive things, and this is a stretch. And the recommendation of community corrections is a stretch.
Community corrections is mini prison. So first you go to prison when you get sentenced to community corrections. You go to prison until a bed opens up in community corrections, and who knows how long that takes. Usually, I don't know, a couple months. And then in community corrections, you start off locked up. And then you take classes, you see therapists, things like that, and you earn your way out. So the first 3 months of community corrections, he might be completely locked up. Then he might start taking some classes and, talking to a therapist and start taking some mental health meds and things like that. So then he'll earn, maybe he can go get a job. But he goes to his job. It's like work release. And he comes back and he's locked up. And then if he's good, he behaves and everything, then he can go home for weekends and work his job. And then, he goes through levels until he gets his own place. They help him get his own place, where he's reporting and things like that. But he's not locked up anymore. So it's not prison. That's what it's not.
I don't know anything about the Arches program. I don't know what that is, but it appears that ACRC has it. And it looks like he's only approved in the Arches program. So here's the thing, sir. They're right. They're so right to be hurt and mad and want to protect the community. And the DA has a right to be here, and she should be stomping her foot at me, which she did for really good reasons. Candidly, because of the progress that you've made and the acceptance that you've taken for your choices, I think there's a mitigated sentence that's appropriate here because of what you've done. Not much, and I want to talk to you about that in a minute. So upon your plea of guilt, sir, I think it's to attempted second-degree assault, class 5 felony, I'm going to sentence you to 4 years in community corrections. Here's what I want you folks to understand. The fear that you have about whether he'll hurt somebody is entirely legitimate. But now it's my fault, and it's my problem if he does. You did what you could to tell me the risk that he faces to the community. Thank you for reminding me about that. I'm giving you this break, sir, because it seems to me that you've earned it. But I want you to hear, in this courtroom, a 4-year ComCourt sentence, if he fails, I won't entertain any arguments. It's not going to get reconsidered. He will go to prison for 4 years, period. There's no discussion. In my courtroom, that's all there is. So rest assured, if he does what you're afraid he will, he's going to prison, period. All right, I'll dismiss then the remaining counts as part of this disposition. That's counts 1 through 3. I will order dismiss the misdemeanor matter referenced in the plea agreement 25M5509. I'll remind the defendant for the duration of this sentence, he must comply with the mandatory protection order, have no access to firearms. Against the sentence I've imposed, the parties originally calculated 5 days, but I can't remember if the PSI noted the same amount. They only noted 2. The parties have agreed to 5. I'm not going to change that. There is a restitution order, motion. Mr. Groskobauer, you made reference that perhaps okay.
To the one filed about a half an hour ago, it just has an updated address with the same amount of money.
All right, what I'm showing then, just to make sure it's entirely clear, is to Miss Wolf, Piltingsrud Wolf, correct, ma'am? The amount is $1,867.94. To Mr. Piltingsrud, the amount is $5,165.93. Is that what you thought you were agreeing to?
Yes, Judge.
The court will enter an order then for restitution in that amount. There's also some other fees, costs, and surcharges that you'll have to pay, sir. I'm not going to impose a fine because I want you to pay them. That's where I want the money to go. I'll remind you, sir, that there's no reconsideration of this sentence without prosecutorial consent. So the victims aren't surprised. Here's what happens sometimes. Somebody gets into ComCore and I get a notice saying they're doing really well. Things are going really well for them and asking me to reduce the sentence, to change it. Under the terms of this agreement, I can't do that if the prosecutor doesn't agree, and I won't. So I want you to know it's not as easy as filing something with me to make it simpler, to make it easier, to make it less harsh. All right. Have I missed anything for the people?
No, thank you.
Have I missed anything for the defense?
Judge, the court dismissed the misdemeanor and vacated the court date tomorrow.
I didn't do that yet. I will order vacated any future court date in the misdemeanor matter as well, as is my habit, and I'm not going to change it here. I am going to order the defendant remanded pending placement in community corrections. Mr. Groskobauer, if there's anything that he wants to give you now, this is the time before he goes into custody.
I'll grab that from him. Thank you.
Subject to the sheriff's. We do need to set a placement review to make sure he's in. I'd like to do that in about 30 days. If you're in custody, sir, that is, if you're in community corrections, you don't have to come back and see me. If there's something that's going wrong and you're still at the jail, I need to get you back here. Okay. September 14th at what time? At 8:30. And again, that's vacatable if the defendant's been placed. Work for the defense?
Yes, that's fine.
Work
For once, Bobby, you're right.
for the people?
Yes.
All right, thank you. Thank you so much, folks, for coming. I'm very sorry.
Did the court want this video for the record or no?
If you wish it to be part of the record, I will make it part of the record. Yes, ma'am. Thank you.
offense. The other cases are being dismissed as part of the global. We're proceeding to sentencing as an open sentencing on those 6 cases. I'll hear first from the people as to your recommendation.
Thank you, Your Honor. And if Ms. Doherty has any representations as well, would she be willing to share those with the court as well?
Oh, she can absolutely. Any either before or after you, whatever you'd like.
Do you have a preference, Ms. Doherty? It doesn't matter. Okay. Let's hear from Ms. Doherty first, if you don't mind.
Okay, thank you. Mr. Conti started with me several months ago, with October 21st of last year. And when I first met him, he was struggling significantly, homeless. I think he struggled with substances, very combative. I think his history with the new charges that we're dealing with right now is reflective of that. I can tell you that my recent interactions with him have been a 180-degree turn. I think he's more stabilized. I know he recently went into a couple different treatment programs. I've not been able to receive verification on what was recommended. The last program was...
I agree, V. I think he's going to end up in prison, but it'll be for more than 4 years, and here's why I think so. He's going to mess up, and he's going to get sentenced in that case, and then he's going to have this 4 years added on, but who knows if it'll be a concurrent or consecutive.
Springs. I did speak to them and confirmed that he was there. I did give him an oral talk swab today. It was negative. He reports he has been maintaining his sobriety. When he first was sentenced, clear back in October, we had tried to transfer him to Denver. He had indicated that he had stable housing there, but was unable to get in touch with the friend that had his identification. He can probably speak more to this. And long story short, became homeless there. Ended up in one of the mental hospital or treatment facilities there, and then later ended up in Colorado Springs, and the most recent one, Cedar Springs. So I really don't have anything to offer the court as to that. He has been staying in touch with me. We were not able to get him transferred, but I can say that he was good about checking in with me over the phone, and that's all that I have to represent.
Okay. Thank you for being here and for that information that you provided. Ms. Bush.
Thank you, Your Honor. The people are asking for a longer period of supervised probation with sex offender treatment, and we are asking for maybe at least 6 months of jail suspended. The reason for that is we've sort of wrestled with what sentence would be appropriate here with Mr. Conti, given his history. He has a pretty long history, including theft and menacing, many non-compliance issues on probation and with the court orders in the past, and just really a disregard of people as well, with some of the charges that he has received in those convictions. As Ms. Doherty mentioned, he has been given a probation sentence in the past with treatment. That was over on the Front Range, and that was I remember sentencing hearing back in October, and he wasn't successful there, and he managed to pick up new cases. However, the reason that the people are willing to give him this opportunity with the treatment and a longer probation of supervision is we've seen some more remorse these last few hearings. It just seems like he's has turned a new leaf, we're hoping, and so we're willing to give him the opportunity for treatment. However, we are asking for that jail to be suspended a longer period, just so that we can have some sort of security there if there is a turn with Mr. Conti again. Just to give the court a brief record for the facts with the indecent exposure case. That was a pretty serious set of facts where Mr. Conti was at St. Mary's Hospital. He was seen on video surveillance footage where he was in his wheelchair. He wheeled up to another female sitting in the waiting area, and they were talking, and he engaged, and he had his genitals exposed and touched her with the end of his penis. And so that was the basis of the indecent exposure case, which is quite serious. And with the menacing case, that one was also just, again, kind of going along with Mr. Conti's behavior in the past with just having a disregard for people and kind of being violent. He was sitting in his wheelchair, wandering through a parking lot, asking for money and cigarettes, and had asked another male for a cigarette. He said no, and then got verbally aggressive and said that if you come any closer, I'll slice you up and down, using a slicing gesture with the knife, swinging it up and down. So those two are the most serious cases that the prosecution just want.
All I'm saying is if you assault someone with a gun, they take the gun. So, I mean, confiscate it. Just remove it.
To highlight here, again, we are asking for a longer supervised probation period with that sex offender treatment and asking for at least 6 months of jail suspended here.
Thank you, Ms. Welsh. Ms. Hawkins?
Yes, Your Honor. I'm going to talk about the menacing case first because he had a felony public defender on that case, and he's not able to be here for sentencing today, but he left me his notes. With that felony menacing case, there was actually surveillance video of what had occurred, and the video showed that Mr. Conti did not approach the victim. The victim got out of the car and approached him, and Mr. Conti has a history of being homeless, being on the streets, and because he is in a wheelchair, people see him as an easier target. So I do think that case had a pretty good self-defense standpoint there. However, Mr. Conti did take out a small knife, and he wasn't supposed to have that, and he understands that. But I don't think that case was very, like, Mr. Conti throwing himself at the situation. It was kind of a two-way street, and it looked to be like a strong self-defense claim there. Mr. Conti has quite a history. I'm sure you've read the report, but he really didn't start picking up any type of cases until about 2019. And then this stint from 2024 was just extremely out of character for Mr. Conti. He's in his 50s. He did not have a history of criminal behavior before that. 12 years ago, he was in a really bad accident where he lost his leg. His brother also committed suicide back then, and it really impacted Mr. Conti, and it impacted his family. He ended up losing closeness with his sister due to some relationships there, and from his family, he really only has his mom to talk to. His mom has alcohol issues. Mr. Conti grew up around that. And so that's really his support system. Back in October, when Mr. Conti pled and he went on to probation, he went into a sober living facility. When he was in that sober living facility, he was doing really mentally unwell, and he tried to kill himself. And it brings it back to here where in Grand Junction, he picks up all of these cases, and it is really emotional for Mr. Conti because he's not the type of person where in his past would have picked up these cases or would have been seen as someone that was victimizing society. He's always told me that he's really enjoyed helping people, and when he's been homeless in Denver and homeless here, he gives people his items. Being in Grand Junction, he was actually brought back here with that probation revocation, and he lost a bunch of his stuff in Denver, including his prosthetic leg, his ID, his any type of money he had. He lost complete access to it, and he ended up back here. Here he did, and he will tell you this, use just about everything that he could get his hands on. And that is what led to all of these cases, and that's what led to a bunch of the behavior issues. Since Mr. Conti was picked up and put in jail in March, he has remained sober. So from March to now, he has been sober after what you could call a bender the last few months prior to that. This case, in particular, the case with the sex offense, has been an extreme wake-up call because Mr. Conti does not have any history of sexual offenses. And And the felony also, Mr. Conti does not have a history of felonies. And so that was also a major wake-up call. And when he was in the jail, we talked a lot about this sex offense. And it comes with a lot of its own punishment, which is the stigma and the label and the registration requirement. And that is something that we had to talk about, and that's something he's had to come to terms with. He made it back to Denver, and on his own accord, he did the PSIR, and he followed through with that. And he's been keeping up with probation now, whereas in the past, he had a harder time with that. And while in Denver, he saw that he was really, really struggling going through this PSIR, as it was really emotionally taxing and it asked you a lot of really uncomfortable questions. And he admitted himself to a hospital, and that's what he needed to do, because it's better than turning to drugs or turning to suicide. And Mr. Conti made that decision for himself, a decision that he hasn't been able to make in the past. And so we're very proud of him for that. We did not do that for him. He did that for himself. In that hospital, that's why we had to move this sentencing date to now. Since getting out of that hospital, Mr. Conti got himself into a sober living facility. And that is not easy in its own, but it's especially not easy because of the sex offense case that he has and because of that registration requirement that he will have. And he understands that it is going to make life a little harder for him now. But Mr. Conti is making these decisions for himself, and I think that's the biggest difference that we have here than we do back in October of 2025. And I think that he will be successful on probation. He was able to get some stuff back for himself in Denver. He's been able to keep a place to live. Mr. Conti looks healthy. I know you didn't see him months ago, but he looks like a completely different person. He looks extremely healthy, and I think that these behavior issues, while he's still, of course, struggling with his mental health, because that just doesn't go away, especially when something like this is such a shadow, he is dealing with it and he's making the better decisions. He's not turning towards drugs, and he's remained sober since March. So we're very proud of him for that. With that, Your Honor, I would be asking here today for a term of probation. I don't think any additional jail time is necessary. I've done a lot of my own calculations. It was, with the probation revocation cases, a little bit hard. Data access isn't the most friendly. But I will say in that PSIR, one correction I did have actually was the amount of jail that they credited for that sex offense. I filed a motion in March that was granted in April that his bond be revoked and reinstated. So he actually has 44 days. However, that doesn't take into account about 31 days that he was actually in the jail before that motion was granted. So he has quite a lot of jail time on that case. The most jail time he has on those cases, in the 26 CR 56 case, I've calculated 72 days. In the 24 CR 1292 case, I've calculated 68 days. 25M 3582 is the 44 days. 25M 3564 is 31.
Hang on, sorry.
Oh, sorry.
Read that last one more time.
Yes, 25M 3564 is 31 days.
Say that one more time, I'm sorry.
Yeah, 25M 3564.
Yeah.
31.
Okay.
And then 25M 3641, I have 35. And then the last one is 24M 2663, I have 54. Again, a lot of those, that's just because the motion was granted in April, but he was in jail for a good month more than the actual technical credit dates. So he was in custody that whole time. I do believe the evaluation said that Mr. Conti, that it was not being recommended that Mr. Conti do sex offender treatment. I think that on that day of that event, Mr. Conti was under the influence of a lot of drugs. He didn't really even remember it, and we had to talk through it, and there, of course, was video. And so with that, he is here today taking responsibility, and a lot of that was drug-induced behavior that since March he has been sober with. He is extremely embarrassed by that. He's extremely apologetic by that. He grew up with a sister. He doesn't have a history of any type of sexual assaults or offenses against anybody. And Mr. Conti himself has been a victim of that. So that's something that he really, really struggled with while these last few months. But with that, Your Honor, I do think that Mr. Conti can abide by probation. I do think he can abide by drug testing, and we would ask that he not do any additional jail.
Mr. Conti, what would you like me to know or consider?
Oh, Your Honor, like I said, I'm very embarrassed about the situation. This is, it's an awful situation. Should have never happened. And, it was such a shocker for me once I saw the video. It just, it was, I have very little recollection of that night. And, it definitely does not reflect upon me at all. As far as the menacing case goes, I really have a trouble with that, but I had to do the global plea. So I just, and I was really struggling in jail, Your Honor. I was, I would have said anything to get out of jail at that time. I was mentally struggling so bad. I've never been in jail for that long a period of my life. I never thought I would be, and I'm embarrassed about the whole situation. But I'm just so glad children weren't there that night. That was my, after the fact, that was the only saving grace that I could see, because I don't know how I would, handle that, detrimentally affecting an adolescent with my behavior. It was very inappropriate, but it was so inappropriate. I mean, I almost didn't believe it was almost an out of body experience. I took a half ounce of mushrooms that night. I don't know what I was doing. It was, it was an awful situation. I was picked up by a couple girls and taken to Taco Bell, and they were kind of flirty with me. And I went in the bathroom and I came out with my pants down, and I don't remember a thing, Your Honor. I mean, it was awful. I mean, it was so out of character that I can't even, it's like an out of body experience. And, I have to face it. 5 years of being a sex offender is like, I can't tell you how detrimental that is to my mental health, to my stability with housing. Mm-hmm. I've been homeless. It's an awful charge, and I wanted to plead with the prosecutor, and I understand. It was an awful experience. I mean, I watched the video. It was awful, and I didn't have to watch much of it once I saw a little of it. I was like, oh my God, it all came back to me. And it was just like, it was a flood of embarrassment. And I didn't really even recollect the whole experience until I was in jail, because my public defender initially thought it would be, I thought it was just kind of, something I'd be able to get dropped, or, it'd be something that, lowered. I had no idea just how impactful it was and how horrible it was. It was just, so I had to take responsibility. Once I saw it, I just, what can you say? I did it. It was, completely out of character. I really do not need to be stigmatized anymore by taking any sexual classes. It was just the PSR, that thing I had to do it was so, I mean, it was awful. I mean, I felt like it made me feel awful. I mean, I physically got ill doing it. It was awful, asking you sexual questions. It just makes you feel awful. I'm not a threat to the society. I'm not a threat to the community. I've never been. So, it's a very hard thing for me, to have this label for 5 years. It's really,
Which sober living house are you at?
it's in Pueblo. It's called Iron Horse.
Are you going to be living in Pueblo now?
I am going to be, yes, Your Honor.
Okay. So I'm assuming the request is to transfer probation there?
Yes, Your Honor.
Okay.
And Chelsea's all right with that.
Okay. For the people I meant to ask, was there any record as to VRA since we're on VRA sentencing on a couple of these cases?
We are VRA compliant, Your Honor, in both and in all of the VRA cases.
Okay, no one wanted to be heard then, I'm assuming.
Correct, Your Honor.
Okay. All right. Well, the court had an opportunity in each of the cases that we're proceeding to sentencing on to review. On the cases that had arrest affidavits, I've also reviewed the lengthy report that was submitted by probation, including the offense-specific evaluation. I've heard the statements of counsel, and I've got, I want to do the following. I'm going to start with the probation revocation cases. On 24 CR 1292, I'm going to revoke probation. I'm going to terminate it unsuccessful. I'm going to impose 68 days of jail with credit for 68 days that you've served. On 24M 2663, I'm going to revoke probation, terminate unsuccessful, impose 54 days jail with credit for 54 days that you've already served. On 25M3641, I'm going to impose 10 days jail. That's the mandatory, or that's the maximum sentence, but give credit. He's already done 35 days. So that will be closed. On 25M3582, I'm going to impose 44 days of jail, but give you credit for 44 days that you've already served. As to the other two cases, the 26 CR 56 and the 25 M3564, those are going to be probationary sentences. I'm closing the other ones, I think, just in a little bit of simplicity for us, so that we can really focus in on the issues. I'm going to first focus on 25 M3564. The court is going to order 2 years of probation. In reviewing the offense-specific evaluation, the evaluator says on page 17, outside of this offense, the evaluation did not reveal significant issues related to Mr. Conti's sexual behaviors or interests. Given the above, sex offense-specific treatment does not seem to be the best use of resources in addressing Mr. Conti's illegal behavior. Alternatively, by targeting his mental health problems, substance abuse, and general life instability, his risk for sexual reoffense will also decrease. Because the evaluator is not recommending that he complete offense-specific treatment, the court is not going to order that. And I know that's highly unusual on this type of offense, and it goes, it's not what the people asked for. But really, I have to rely on an evaluator because I'm not someone who has an expertise in this area. And if the evaluator is telling us there are certain areas that we need to focus on to ensure that Mr. Conti's opportunity or likelihood of recidivism can be decreased, then that's what the court really wants to focus on. So I'm taking the recommendation of the treatment provider or the evaluator. I'm going to order conditions of probation consistent with their recommendations. This does recommend community corrections, but that's not a potential sentence on these misdemeanors. So that first recommendation the court's not adopting. 2, it says that he should be referred to an intensive dual diagnosis treatment program. It sounds, I didn't get a lot of information about what he was doing at Cedar Springs. I mean, I have some independent knowledge from that about what happens at Cedar Springs. So my understanding is you've probably already been focusing on those dual diagnosis issues, right? Yeah. Combining, making sure you're managing your mental health and your substance abuse. Yeah. Simultaneously. So what I'm going to order is that he continue to address his dual diagnosis issues. I'm not going to order a specific place or a specific program because now that you've completed Cedar Springs, I don't know what the follow-up care is, but you have to continue to address both of those things. I'm also going to order number 4 on her recommendations as a psychological evaluation to help clarify your diagnosis and provide recommendations for intervention. I'm also going to order monitored sobriety. So I'm ordering you to abstain from using any substances you do not have a prescription for, as well as alcohol, and you're going to have to be monitored.
Can you not refrain me from alcohol? I wasn't refraining from it before, and Your Honor, I'm not a big drinker.
I'm going to refrain you from using any substances based on the behaviors in these cases. So I'm alcohol and any substances. I want you to be completely sober for 2 years while you're on probation.
I have a
so that you can. And I'm not going to prohibit that unless there becomes a reason to prohibit it. Okay. But I really want you to get clear-headed, because what you had just told me is that you were using so many substances that you don't remember committing a sexual offense. So I have real concerns if you're not sober about the choices that you're going to make. And that's the reason that I'm ordering continued sobriety.
Okay. The only thing is with the continued sobriety, I respect that.
Okay. I'm going to keep doing my sentencing. Okay. All right. There's some other things in here, like seeing a primary care physician to ensure that you're sleeping, working with a caseworker. I think all of those things are inherently wrapped up in pro-social activities that hopefully we are going to get through his probation supervision. And finally, again, on number 10 here, it says it does not appear necessary for him to be required to follow SOMB rules and requirements. It is not recommended that his internet use be restricted. So interestingly, and I don't know if it was a typo or something, but in the probation's recommendations higher up, and I can get to the page, I just got to find it again. It says here, under special additional conditions, it says the OSE recommends the court order condition 23, but I think it explicitly says do not order condition 23. So I think maybe that was just a typo or something from a previous report. So the court is not ordering any additional restrictions as it relates to the internet. However, so I'm not ordering 23, 24, 26, 25, but I am going to order 27, which prohibits you from patronizing any place where sexual oriented or sexually stimulating material or entertainment is available, except under circumstances approved in advance and in writing by the probation officer. I'm also prohibiting you from using or possessing distant vision enhancing or tunnel focusing devices or cameras. Well, actually, I'm not going to order that you can't use the cameras without permission, but you can't use like binoculars and things like that to spy on people, okay? As a condition of this. Not the facts related to your case, but sometimes that is an issue for people with sexual offenses.
Don't have any issues with it.
I'm also going to order you to register as required under the statute. That will be a condition of probation, is that you maintain your registration. As to 26 CR 56, I'm also going to impose 2 years of probation. I'm not going to put any other additional terms on it because I think we've outlined the terms in the 25M 3564 case. As for transferring probation, Ms. Doherty, does he need to stay in Grand Junction until he transfers, or because you already have a relationship? I want to set him up for the best way to be successful. So what does he need to do?
So I do need to review the updated terms and conditions that he was sentenced to today, so he's aware of what's expected of him. I need to complete a supervision transfer agreement, transferring him, which I've already indicated that to him, that we need to meet following court today if he was granted probation. I do have a question. He gave me the address 2521 Taylor Avenue in Pueblo, but I just heard him say he would be at the Iron House. Which is it?
That's the same place.
That's part of his sober living?
Yeah, it's the name.
I'll follow up with that to verify that.
Okay, and how long does he need to stay in Mesa County? I just want to make sure he knows exactly what he needs to do.
Long enough for us to get him transferred. So, I mean, if we can get it today, I can get the paperwork transferred. But if the paperwork doesn't come through till tomorrow, then it could be till tomorrow. But typically, you guys are pretty good about.
Do you have somewhere to stay tonight?
I do.
Okay. All right. So you cannot leave until you've confirmed with Ms. Darty, gone over the new terms and conditions. Okay? Okay. And then my expectation is, as soon as you get to Pueblo, you need to call the probation department and get your first meeting scheduled right away.
Yeah.
Okay? All right. Then there's a handful of other cases. The court's ordering 25M 3597, 25M 3601, 26M 135, 26M 467, 26M 363, and 26M 577, 26M 586 dismissed, but not sealed because they've been part of this global. All right, I'm not suspending jail. I understand, and I think it's a very reasonable request by the people. I'm not comfortable binding myself in the future because in the future, depending on what happens, I could determine that a longer sentence is appropriate or a shorter sentence. I'm not sure because I don't know what you're going to do. But I'm sentencing you to probation because I believe you can be successful in the community and you don't belong in the jail. But it's going to require you to follow through on the work that you have already done. You have to maintain working on your dual diagnosis. You have to maintain mental health treatment, substance abuse treatment, do that psychological evaluation as I've ordered, okay?
Yeah.
All right. Are the people seeking restitution? I can pull up the please.
In my case, yeah. In none of the cases, Your Honor.
No, okay, the court's not ordering restitution then in any case. All right, we're going to finish getting those entered. I think that's all we need to address. Is there anything else the parties wanted me to address?
I don't think so, Your Honor.
They might want this back with my signature on it. If you can put that just in the 25 3580 or the 3564.
These are the terms and conditions.
That's, yeah, but it's just, I'm only ordering the one extra, yeah.
Does that mean?
Probably to probation. Do you want, I've only checked one box on the additional conditions. Do you want us just to upload that into the record or how do you want that back?
Yeah, however you guys.
I just don't know what the local practice is for it. Just upload it.
Yeah.
And then everybody can see it.
Trujillo appears in person. He's pro se. The people appear on behalf of Ms. Hardy. We're set for a hearing for revocation of probation today. Are we moving ahead with the hearing?
Judge, I was under the understanding that the defendant was still to provide his social security information to the public defender's office. The public defenders I see have not entered yet. We do have the probation officer on WebEx if the court wishes for us to proceed to hearing today. However, I know that the defendant had previously indicated he wanted counsel.
He did indicate that he wanted counsel. I then gave Mr. Trujillo 4 appearance of counsel dates. He did not complete the process for obtaining the services of the public defender's office. Public defender's office needed Mr. Trujillo's SSI verification, which it did not receive. Court made a finding on July 6th that Mr. Trujillo had waived counsel based on the failure to complete the application process. Are you ready to call your first witness, Ms. Hardy?
Yes, Judge. The people would call Mr. Garrett, the probation officer, to the stand. He's
All right.
appearing virtually on WebEx at the moment, Judge.
Mr. Garrett, will you raise your right hand for me, sir? You swear or affirm under penalty of perjury that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay.
Mr. Garrett, can you state and spell your first and last name for the record, please?
Randy Garrett, RandyGarrett.
And why are you here today, Mr. Garrett?
I am here to attend the probation revocation hearing for case number 23M54.
And what is your current role in the probation in that case?
I am a probation officer for the 16th Judicial District.
And have you been supervising the defendant in this case?
I did for a period, yes.
And can you explain to the court the dates in which you were the supervising probation officer for the defendant?
If you give me a moment, I can look it up. I don't know the exact dates.
Sure. And Judge, while we're waiting on Mr. Garrett to do that, the people would like to request that the court take judicial notice of the conviction in this case which I believe is dated May 20th of 2024.
Court will take judicial notice of the conviction dated May 20th, 2024.
Similarly, Judge, the people would also ask the court to take judicial notice of the sentence to probation and the terms and conditions of probation. I believe the terms and conditions were also done May 20th of 2024.
Court will take judicial notice of the sentence to probation and the terms and conditions of probation.
Mr. Garrett, were you able to find those dates roughly for us?
I'm getting closer.
Fair enough.
It looks like administrative supervision transfer was done on May 7th of 2024.
Thank you. Now, would you be able to identify Mr. Trujillo if you were to see him here today?
Yes.
And are you able to see him in the courtroom today?
Yes, he is sitting at the defense table in a dark colored t-shirt.
Your Honor, let the record reflect that the witness has identified the defendant.
It will.
Now, Mr. Garrett, let's talk about the terms and conditions of probation.
Okay.
Condition number 1, can you tell us what condition number 1 was for the defendant?
Standard condition number 1 is will not commit any offense and report any law enforcement contact to probation.
Thank you, sir. And I apologize. I am reading off of your supplemental report for complaint. Condition of supervision, the number 1 item listed there was the court assessed amount of $1,089.50. Can you tell us about that condition?
Okay, on the standard terms and conditions of probation, the court will assess fines, fees, and costs. And on his terms and conditions of probation, it was the $1,089.50.
And do you have any information for the court about the compliance with that? The defendant's compliance with the amount owed?
To my knowledge, he has not made any payments towards the fines and fees assessed by the court.
Are you aware of any payment plan established?
I have talked to him a couple times about it in the past, and to my knowledge, he has not engaged in it, setting up a payment plan.
Thank you. Moving on to standard condition of supervision number 6. Could you tell the court what that condition is?
That condition is he will not use alcohol, controlled substances, or prescriptions in a manner inconsistent with the prescription.
Was this condition violated?
Yes, it was.
When?
On February 26th, 2026.
And how do you know that?
Mr. Trujillo was across the street from the Otero County Courthouse in an alley. It was a fairly nice day. Wasn't wearing a shirt. He was right outside the, excuse me, he was right outside the probation office windows, and it was brought to my attention that he was there. I walked across the street and contacted him, and he admitted at that time to consuming alcohol.
Thank you. And moving on to standard condition of supervision number 7, could you please tell the court what that standard condition is?
That standard condition says he will submit to drug and alcohol testing as directed by probation or the court. He will not attempt to substitute, dilute, tamper with, adulterate any samples.
And this condition, has the defendant violated this condition of probation?
Yes, he is required to submit random testing samples. I had him set up for twice a month, and he missed several dates where he was required to provide test samples.
And what are those dates? Do you have those for the court?
June 28th of 2025, July 10th of 2025, August 27th of 25, September 16th of 25, October 16th of 25, December 3rd of 25, January 26th of 26, and February 3rd of 26.
Thank you. And now let's move on to standard condition of supervision number 8. Could you please tell the court what standard condition number 8 is?
Standard condition number 8 says that he will successfully enroll, engage, and complete any referred evaluations, assessments, or recommended treatment.
And was this condition violated by the defendant?
Yes, it was. He is
Can you explain
referred
how?
to managed treatment centers for a substance abuse evaluation and any and MRT. And on July 21st of 2025, he was unsuccessfully discharged for lack of participation and attendance.
And were any sanctions or remedial measures put in place to try and get the defendant to re-engage in treatment?
So we actually applied and received an extension on his probation to assist him with being able to complete the probation. There were verbal warnings.
And what was the defendant's response to those sanctions and imposed warnings?
He continued not to comply.
Thank you. Now, moving on to standard condition of supervision number 9, can you please tell the court what standard condition number 9 is?
Standard condition number 9 essentially is he'll report to the probation officer for appointments as directed by the court of probation.
And has the defendant complied with that condition?
He missed several appointments.
And when were those appointments?
September 25th of 25, November 10th of 25, and December 30th of 25.
No further questions at this time.
Mr. Trujillo, do you have any questions for Mr. Garrett?
I've been in and out of the mental hospital. This is why this is all happening.
Do you have any questions that you want to ask him?
No, he's correct.
Okay. Ms. Hardy, do you have any other witnesses you're calling today?
No, Judge, people rest.
Okay, I will hear your argument, Ms. Hardy.
Judge, probation only works if the defendant actively engages in the remediation efforts and the active efforts that probation puts forth, such as the MRT, the UAs,
I would like to say one more thing.
It's not your turn right now, Mr. Trujillo.
the substance abuse classes and treatment, and showing up to probation appointments is a quintessential part of that. Given the defendant has had multiple intermediate sanctions imposed and he's remained non-compliant, the people do believe that the court should revoke and terminate with an appropriate jail sentence in regarding this matter.
And Mr. Trujillo, I forgot to ask you if you want to testify. Do you want to testify today?
Upon what?
Do you want to testify?
About what? What am I testifying about? I don't want to do something. I don't know what I'm doing. Where is my lawyer?
You didn't complete your public defender application.
Well, what does that mean? Testify against what? Myself, you, or what?
Mr. Trujillo, I'm going to read an advisement to you about your right to testify. Mr. Trujillo, you have the right to testify. Do you understand that?
Yeah.
If you want to testify, no one can prevent you from doing so. You may take the witness stand even if it is contrary to the advice of an attorney. Do you understand that?
Yeah.
If you testify, the prosecution would be allowed to cross-examine you. Do you understand that? If you've been convicted of a felony, the prosecutor would be entitled to ask you about those convictions. Do you understand that?
Yeah. What if I don't testify?
I'm about to tell you about that. You also have the right not to testify. Do you understand that, sir?
No, I do.
If you do not testify, no inference of guilt can be drawn from the fact that you did not testify. Do you understand that?
Yeah.
The decision of whether to testify or not testify is a decision to be made by you. Do you understand that?
Yeah.
Do you want to testify or not?
What am I being charged with?
There's a complaint to revoke your probation.
So what if I don't testify? What happens?
If you don't testify, I'll make a decision based on the information I've heard.
So what if I do testify?
I'll consider the information that you offer me as well.
So I'm facing jail time right now?
Yes.
And what if, so I testify and that'll save me from going to jail?
Not necessarily.
Oh, no, I don't want to testify. I'll just go with it.
Is the decision that you're making not to testify the result of any pressure, influence, or coercion?
No, I really don't know what to do right now, but I have no choice, so I don't know what to do. I don't know. I won't testify. I know what I'm doing, but I'm not too sure. But I'm just going off of what I know, and I don't want to testify. I did what I did. I'm facing it.
Are you under the influence of any alcohol or drugs today, Mr. Trujillo?
Marijuana.
You're under the influence of marijuana today. When did you last have marijuana?
At 4 this morning when I take my pill the first time of the day. Then I take one at 12, and then I take one at 6.
Ms. Hardy, do you have any motions regarding the defendant's bond?
Judge, the people would motion for the court to revoke Mr. Trujillo's bond, given that he's under the influence and violation of his probation and this court's order. And
But I have my medical card.
Please don't interrupt, Mr. Trujillo.
and that the court set this over when Mr. Trujillo is sober so that we can continue our probation revocation hearing.
All right. Court's concerned about whether Mr. Trujillo is competent today. Court's going to make a preliminary finding that it does not have enough information to determine competency. Court's going to revoke Mr. Trujillo's summons. Court's going to set bond the amount of $501 cash only. Competency is going to be determined in custody until and unless Mr. Trujillo posts his bond. Going to continue this matter until August 17th. One second, please. August 17th at 3, that'll be hearing for revocation of probation.
Judge, could we continue Mr. Garrett's subpoena on the record for that date and time?
Yes, Mr. Garrett, your subpoena is continued until August 17th at 3. And we'll set a review for competency on September 21st. That'll also be at 3. Deputy, will you please remand Mr. Trujillo? Court finds that bond is revoked based on Mr. Trujillo's admission to consuming marijuana earlier today. The court does not make a finding about whether his decision not to testify is knowingly, intelligently, and voluntarily made. We will be in recess in this matter. Court appoints the public defender's office to represent Mr. Trujillo.
All right, this is 26M30. Mr. Powers is present. Ms. Bench is here for the people, and Mr. Powers just handed over some paperwork The clerk is entering that into the computer.
Judge, I did go steal it back from her.
Oh, you stole it back.
Yeah,
Okay,
but-
tell me about it, Mr. Powers.
Judge, we have a different agreement than what was on the paper, and so I'm just having Miss Bench change that and initial it.
Okay. All right, and he's handing it back to the clerk at this time.
Thank you.
Ms. Gorman, I have in front of me a guilty plea and waiver of rights. It says that you would plead guilty to obstructing government operations, a public servant, a class 2 misdemeanor.
Yes, ma'am.
And the recommendation is that the case be closed out with credit for time served. The remaining charge would be dismissed. Is that your understanding as well?
Ma'am.
Say that again?
Yes.
Okay. And I see that your signature was written in here by Mr. Powers. It says, on your behalf with your knowing and voluntary consent. Is that right?
Yes, ma'am.
Okay. Before asking him to sign this for you, did he explain everything to you?
Yes.
Are you satisfied with his representation?
Yes, ma'am.
Are you in the military or have you ever served?
No, ma'am.
To the charge of obstructing government operations of a public servant, do you plead guilty or not guilty?
Guilty.
Is anyone threatening or forcing you to do that?
No.
Are you under the influence of any drugs, alcohol, or medicine which would affect your ability to understand what's going on?
No, ma'am.
Do you understand the charge, the elements, and the penalties?
Yes, ma'am.
Do you understand that when you plead guilty, you waive your right to a trial?
Yes.
Has anyone made you any other promises?
No.
Okay. I'll accept your plea as knowingly, willingly, and intelligently made. The remaining charge is dismissed. Ms. Bench, I'll receive I think I reviewed this affidavit. I do find a factual basis for the plea. Ms. Bench, I'll hear from the people on recommendation for sentence.
Yes. So my understanding of the facts is that when the law enforcement went to Ms. Gorman's address in order to serve her with some legal papers, she answered the door, stated that she was her sister, and then left the house and got in her car and left at a very high rate of speed. Officers were flagged down by a worker at Argento Marble, a local business, who stated that the defendant's vehicle sped through their parking lot, almost hitting her and her employees. When she yelled at the driver stopped. The driver indicated that they were running from the cops. Then her car was found behind the Napa auto. Ultimately, she was found sitting at the bus stop with a beanie on her head and different clothes, and the police ultimately had to hold her at taser point. Ultimately, I think it's fair that she take a conviction here based on those circumstances. That is a very, very dangerous situation, not only for herself, but also officers that she put herself in. And frankly, I'm glad that nothing more serious occurred. So ultimately asking for the court to close this out with credit time served. My understanding is she's got a lot of stuff going on in the 7th, my former jurisdiction. And so I think likely to reach out to the Telluride San Miguel County prosecutor, Mr. Bama, on her behalf, I think asking for this to not I think have more significant consequences than it possibly could out in the 7th. So still fully intend to do that, asking the court to close this case and send her off to the 7th. Thank you.
Mr. Powers?
Judge, it's going to be my request that the court close Leah's case out with the 2 days of credit that she has in this case, which are from March 12th and March 13th of this year. Ms. Gorman has suffered from a multitude of mental health diagnoses her entire life. her most formal diagnoses, her most serious formal diagnoses is probably her bipolar 1 diagnosis. It was a chronic mental health condition characterized by extreme mood swings, right? Leah has told Ms. Stillman, whose notes I am largely pulling from, that when she's in a depressive state, she can't get out of bed. But when she's manic, she can't sleep for days on end. And usually those manic states end up with situations kind of like this. I've known people that suffer from the same exact thing. And Leah's, worked with, a number of health professionals for 20 some odd years, is good about taking her medicine. She does everything that she can to control this. And I've known people that do the exact same thing and it just doesn't matter, right? You can lose your control whenever you're suffering from, bipolar 1, BPD. It's a scary thing. The Leah that I've known the entire time that I've spoken with her has always been polite. She's great about calling. She's honestly very fun to talk to, very polite to me always. She's just a great person. And, I watch what happened in this case and, that's not Leah. It's just an incredibly difficult thing. And it's a scary thing that these are just, normal things that can happen. But Leah is not some hardened criminal. Leah is a good person. I truly do believe that. I just think she suffers from, a incredibly difficult mental disorder that hijacks her brain and causes her to sometimes do things like this. She's going to have a conviction entered for this, a conviction that, realistically could cause other problems with her. She did go to jail. She was there for, 2 days. And so I think I think that's more than enough for a case like this. So I would ask the court to just sentence her to 2 days of jail with 2 days of credit for time served. And that's my final request.
Ms. Gorman, did you want to address the court before I impose a sentence in this case?
No, miss.
Say that again?
No, thank you.
Okay. Well, Ms. Gorman, as I recall it, I think it was protection order paperwork that they were trying to serve on you. So let me just look that up real quick. If that case still exists. Okay. Yes, so this is a permanent protection order. If you have any questions about it, call the courthouse, but I just want to make sure that you know that that is what is in place. And they did attempt service on January 6th and were unable to, but they did sign it, or they did serve it on you personally January 15th, just before 3:00. If you don't know what protection order I'm talking about, go ahead and call the courthouse back here in Glenwood Springs. We can make sure that you have a copy of that because that will remain.
Thank you.
You're welcome. That will remain in effect indefinitely.
Okay.
Ms. Gorman, I wish you the best as you kind of navigate these cases that you have outstanding. I think in preparation for that protection order, I saw some cases out of Summit County and I don't remember where else, but I do hope that you find some stability moving forward and that you rely on your resources to help you with that, whether it be your defense counsel or any local services that you might have. As I recall, you're not working, is that right?
Yes, ma'am.
Okay. So the court does not impose a fine. The court does impose the fees, costs, and surcharges.
V, I'm sorry I missed that on Twitch. Look at that. That's really cool. Thank you so much. What else did I miss? Oh my gosh. You gifted a membership to Elf Eora. Thank you so much. Thank you. I appreciate it. I'm sorry I missed that. I wasn't looking at Twitch.
2 days of jail with credit for 2 days served. That means that you do have a balance that you owe. Is it $26.50?
Okay.
Give me a moment while we figure out what it is. Okay. So you will owe a balance and you must pay that in full or set up a plan within the next 7 days.
Okay.
Do you have the phone number to call the courthouse or the person that you set up the payment plan with?
No.
Do you have a pen and paper?
Give me a second.
Sure.
That's it. She's just gonna
Okay, go ahead.
give her the information. I just feel that if you use your sister's name, you should go to jail for a decade. That's what I feel. But, karma. Guys, thank you so much for coming out. I appreciate it. We got a couple more days left in this week. This long week. Actually, today's Friday, so we just have today and tomorrow. I shall see you all again tomorrow morning. I hope you guys have a great night. I appreciate it. See you guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace, come join the fun. It's a welcome play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guarantee.